Good afternoon for those of our listeners on the East Coast, and for everyone else, good morning. This is a webinar that's presented by Cohen Seglias on buy-sell agreements and their place in an asset protection plan. It's part of a series that our transactional wealth preservation practice group provides as a resource to our clients and to our business associates. My name is Brian Lawton. I'm an attorney in our business transactions group. I'm located in Cohen Seglias' Pittsburgh office. First, I'd like to start off by saying that I hope that you and your family are staying safe as we deal with this coronavirus pandemic. Second, as a couple of housekeeping matters, I'd remind our listeners that the webinar app that we're using today has the ability to pose questions. If you please pose those questions in the section of the webinar app that's referred to as questions as opposed to chat. If time permits, at the end of the webinar, I'll try to answer any of the questions that we received today. Otherwise, if I'm unable to do so, either because of time constraints or because of the detailed nature of your question, I will respond offline after the conclusion of the webinar. In addition, I would note that we have the slides that we'll be going through today posted, and if you'd like access to those written materials to use or refer to offline, you're welcome to do so. When I meet with clients to plan for a buy-sell agreement for their company, often the client has an idea of what they want to do, but not how to accomplish it. And because it's important for me that the client understands what he or she's getting into, we spend a lot of time discussing the fundamentals of a buy-sell arrangement, what it is, why it's important, how to structure the arrangement, and when to start. The amount of information that we cover in these type of planning meetings can be overwhelming for the client. And so my main purpose today is that I want to introduce you to the issue, hopefully to spark some thoughts and assist you with understanding the importance of it. When you make the determination to pursue this matter yourself for your own business plans, having that fundamental information with you will help you to understand the advantages and disadvantages as you go through this process. I guess the first place that we want to start at is what is a buy-sell agreement? And as essence, it's a contract between the co-owners of the business that governs how the ownership interests will be transferred between or amongst them. Often it's described by analogy to estate planning or domestic relations law, something that laymen may be familiar with, such as a business will or a prenuptial agreement for co-owners. When a business owner first forms their business, it's often part of the process that you'll get an agreement that's set up as part of the organizational documents. So for an LLC, it's often referred to as an operating agreement. For a corporation, there may be bylaws or a shareholders agreement. And for a partnership, it's referred to as a partnership agreement. And so the question arises, when we talk about using a buy-sell agreement, is this another contract that we're adding on top of the existing agreement for the company? More often than not, the answer to that question is going to be no. Typically, while an operating agreement for an LLC or a shareholders agreement for a corporation has a broader purpose, they should contain buy-sell provisions. And so for purposes of our webinar today, what we'll be using the term buy-sell agreement is really intended to be a catch-all term that works across whatever the form of the business that you're operating under, whether it's an LLC or a corporation or a partnership. The analogy to a will is useful in this context because we all know that as we move through life, the will that we might have created when we were younger needs to be updated as our life has changed. And the same often applies with respect to the buy-sell provisions of a business. When I first formed the business, I'm interested in getting started. Very often, me and my partners in the business are going to have an excellent relationship. We understand one another perfectly. And in addition, starting out the business, very often money is at a premium, and there's only so much that I want to invest in getting the company set up. And so the result that you often see is very generalized buy-sell provisions in those initial organizational documents, if it's even addressed at all. And so one thing I would want to challenge my listeners to today is that after this webinar, you dust off those companies' organizational documents and look at the buy-sell provisions. Are there any there? If not, should there be? Is it a circumstance where they're still fit for purpose? If not, then just in the circumstance that you never know when you're going to need your will, you really never know when these buy-sell provisions may come into effect. And so the earlier you get ready for it, the better it is that you can plan for it. So what are some of the, so if you take me up on that challenge, what are some of the things that you're going to want to be looking for in your buy-sell agreement? Or if you're thinking about doing a new one, what are some of those issues that need to be considered? And ultimately, a buy-sell agreement is about continuity and ownership of the business. And so if we go through and kind of review some of the 6 purposes that are typically covered, why one would want to have a buy-sell agreement. One is that we want to be comfortable about who our ownership is going to be. I know who my partners are, and presumably I'm comfortable with them. I don't want to change that cast of characters. Knowing that life events happen and the ownership of a business will succeed, what is the mechanism for that to occur? And how do I maintain that control and continuity? Is there a circumstance where I have that option, or is it an obligation that I have to purchase the ownership of an existing owner if they're leaving the business? Because internal control dynamics can be important and conflicts will often spell disaster for a business. Properly structured buy-sell agreement will be effective to avoid a lot of those internal issues. How we're going to determine the value of the company when one of those events occurs, that is a circumstance of, how do I determine what that value is going to be? And finally, how am I going to pay for it if I do have that obligation to buy out my existing owner? Key to making a buy-sell work is the restriction on the transfer and ownership interests. We think about the distinction between a privately held company and a public company. So public companies are those ones that we hear about every day. There's an established market for the purchase and sale of the company's securities on a stock exchange, for example. And so the buy-sell agreement really applies in the context of a private company. But just because my company doesn't have an established market to sell its shares doesn't mean that transfer of those interests are restricted. If I own an interest in a private company and there's no restriction on the ability to transfer my interest, I can give it away. I can leave it to my family and my will, or I can sell it if I find someone to buy it. So the first step in a buy-sell agreement is to restrict the transfer of the ownership interest. Typically, in the form of the contract, it's going to be the circumstances where you're either going to need to have the approval of the remaining owners in order to transfer the interest, or as an alternative, there can be just a blanket restriction on anyone transferring their interest, or it can be set up in the form of an option. So essentially, if I want to transfer my interest to a third party, before I have the permission, the ability to do so, I have to go to the remaining owners and ask whether they're interested in purchasing it first. Depending upon the circumstances of the business, it could be handled in a wide variety of ways. And one of the advantages in operating a business is that I have a lot of flexibility in how I structure that internal relationship amongst the co-owners. And so the key is that there's that restriction, however the form of it takes. That creates the mechanism by which you can implement buy-sell. So the purpose of this webinar is to discuss the place of a buy-sell agreement in asset protection planning. For many, if not most business owners, the value of the business is their greatest asset. So when we discuss asset protection planning, often the focus is on the external threat, such as claims that creditors against the assets of a business threatening its continued operations. A buy-sell agreement focuses on the internal phase of business perpetuation, preserving that value for the remaining owners. Also for an owner who's departing, who has an investment value in that, making sure that they're going to get fair compensation for their ownership interest. Again, turning to the domestic relations analogy, I'm sure many of the listeners today have heard saying something to the effect that the marriage has never been broken on the outside. I don't know whether that's a true saying, but in the same fashion, often the existential threat to a business continuing its is the internal dynamics of the ownership, whether it's a circumstance that the passing of one of the co-owners or dispute amongst the owners themselves in the operation of the business. Those internal factors often are what will bring the business down. And in that circumstance, a buy-sell agreement can help to protect everyone to the process, whoever's right, whoever's wrong, or if no one's wrong and that we just have a death event, to keep that business going for the benefit of the remaining owners, and for someone who's going to depart, to make sure that they get fair compensation for their interest. So the events that trigger that business succession are typically referred to as a triggering event. And there's a wide variety of circumstances that can result in a triggering event. You want to make sure in your agreement that you identify those triggering events and what the results are going to be in the event that one of them occurs. Some of them are common, others less so. We go through a list of involuntary triggering events, and this is just some of the most commonly addressed, but it's certainly not an exhaustive list. Obvious ones that we'd be thinking about: death, disability, divorce, maybe less so, loss of professional licensure. That's going to be more important to some businesses other than others. Voluntary triggering events probably comes as no surprise to you that thinking through the potential circumstances, less voluntary events that are triggering buy-sell than involuntary, but there are still there. Retirement, and some that could be both involuntary and involuntary, such as the determination to leave a business or a management disagreement. We're going to talk about a number of these, but certainly not all of them. And first and foremost is when people think about buy or sell agreement, the instances that they're thinking about is death or disability. You want to consider whether you want to buy a co-owner's interest in the event that there's a death, or is it optional? There's a critical distinction between an obligation to buy out that interest versus an option. And think about it from the perspective of, is it a mandatory enforceable right that I'm being bought out in the event that I pass? Or do the remaining owners have the option that if they choose to? And you think about this, like most legal matters, as a two-sided coin. If I'm thinking about it from the perspective of my family, so I've passed away, I may want to convert my interest in a business that is typically illiquid to a more liquid asset for the benefit of my family so that they can use those resources for their own purposes. But if I'm on the other side of that coin, and I'm thinking about this from the perspective of continuing, of the co-owner who's going to remain in the business after my partner passes. Perhaps I don't want my deceased co-owner heirs or spouse as my new business partner, but I also have the consideration of I have to pay for that business interest. We're going to discuss later in the webinar about how these type of arrangements can be funded. But you're thinking about it, do I want to put that obligation on the company? Do I want to create that obligation to myself? These are never going to be a one-size-fits-all circumstance. It's going to depend upon the nature of your business. So for example, if I have family members who are heavily involved in the operation of the business, in that circumstance, it would certainly be appropriate that to have the ability to allow a transfer from the deceased owner to those key family members who can help to continue the business. But if they're absent from the business's operations and I'm the surviving co-owner, is it the circumstance that I necessarily want my former partner's heirs to be profiting on the sweat of my brow? It depends on the circumstances of your business. In the same way, when we talk about disability, this is another balancing act that turns on much the same considerations. How do we identify what that disability event is that's going to result as a triggering event? Most often than not, the focus is on a permanent disability that is going to impact the ability for that co-owner to contribute to the business's operations. You want to avoid a circumstance where advantage can be taken because of the misfortune of that owner to create, a duty to sell when they would have the ability to come back in and participate in the ownership. It's when you get to that circumstance that there's some type of their permanent disability that's going to infringe upon their ability to continue to participate in the business, that the remaining owners would have an interest in effectuating a buyout of that, so that they would be able to be operating the business for their own benefit and not necessarily for someone who's not going to be contributing. Buy-sell agreement that addresses disability is going to be focusing upon what is that disqualifying event that's going to trigger that right or option to buy out the partner who's incurred that disability. Typically, it's focusing upon permanent disability that may be identified perhaps with a determination from a medical professional that person is indeed permanently disabled. Maybe a little bit less commonly thought of as a triggering event is divorce, but this is certainly one that's important. Now, the initial first thought may be that my co-owner spouse has no interest in the business. But if you think about it from the perspective of that soon-to-be ex-spouse, if that business interest is the most significant asset that your co-owner possesses, what's the likelihood that the spouse is going to take the same position? Marital property laws vary widely from state to state. We're kind of considering this on a wide multi-state perspective, so we're not going to be addressing those issues specifically, but we will be, certainly the risk is there no matter what state that you're in, that ex-spouse is going to be taking the position that business interest is marital property in which they are entitled. How many of us want our ex-spouse to be a partner in your business? If we were not able to make our marriage succeed, by the same token, we certainly don't want to have that person involved in my business. And if that is the case, it's doubly so for my business partners to not want to have my ex-spouse involved in the business. So buy-sell context, typically what we do is to address this circumstance is I usually take a multi-front approach to this. First and foremost, you want to create a mechanism for the co-owner to retain their ownership interest in the same percentage that they have always had. So you want to put the obligation on them, on that co-owner, to, if the asset is considered to be marital property, then in that circumstance, that they have an obligation to contribute other property to a marital settlement in order to take that business interest off the table. So you compensate the ex-spouse with the personal assets of the co-owner who's going through the divorce. If that does not work, it's not practicable, then typically what you want to do is you want to have a buyout obligation that requires that ex-spouse to sell whatever interest he or she comes into ownership of, because we want to make certain that that stays closely held within the existing ownership group, the consequence being that the interest of the partner going through the divorce is going to be less. Typically, we find a way to resolve that on the flip side once they get out of their marriage and the divorce is finalized. But the key behind that is to keep the ex-spouse out of the business. If it's not addressed in the buy-sell agreement, it could be fair game if that's considered to be a marital asset. Another instance that's even less likely thought of when we're considering a buy-sell agreement is professional licensure. Now, it's not often considered. It's going to be specific upon the type of business that you're involved with. People that are licensed professionals, this can have a great deal of resonance. I identified in the slide some of the instances where we would be thinking about this depending upon the type of business. And so I go back to my earlier challenge to revisit the buy-sell obligations in your existing documents, if there are any. If you fall in the category of a business that requires its participants to be licensed, does your agreement address this issue? And so what the consequences are if there's a triggering event of these natures, so you lose a license as a co-owner, what does that mean for your buy-sell? If it's not addressed in the agreement, then there's no obligation or option on the part of the remaining owners who maintain their licensure to buy out the professional or the former professional who's lost their license. So what's the consequence to the business? The business is organized as a professional entity. It could lose that qualification by operation of law because it no longer is composed of people who are licensed professionals. If it is a circumstance where there could be an ethical or legal violation, if I'm sharing income from that business with someone who's no longer entitled to receive that income because they don't have the professional licensure. Even in circumstances where there's not a legal obligation, all of the co-owners be licensed. An example that I'm thinking of is often in the context of an engineering firm. It's not required that all of the owners be licensed professional engineers, just a requirement that one is. If I have a circumstances as a hypothetical that there's two co-owners who are each 50%, both of them are licensed engineers. One of them loses that professional accreditation. The business can continue as an engineering company, but if I'm the remaining licensed partner, is that much different than the circumstance in which my co-owner has passed away or they've become disabled? They're not able to contribute to the business in the same fashion they once were. Is it appropriate in that circumstance that no longer licensed co-owner remain in the business, even if there's not a legal obligation outside of the buy-sell agreement to address it? Where these issues are not addressed in a professional organization, and one of those events does come about, it creates a huge mess. Having participated in these situations before, where I've come in after the event has occurred and it's not been addressed in the buy-sell agreement. In a worst case scenario, what can happen in those circumstances is that business has to terminate because the people who maintain their licensure cannot continue to be involved in a business with someone who is no longer licensed. Determination to leave the business. This is a broad category that can cover a number of instances. Whether I terminate my employment with the company on a voluntary basis because I want to move on to new ventures, move out of the geographic area. Alternatively, involuntary circumstances where my remaining partners decide that I'm not contributing to the business, they terminate my employment. What does that mean to my ownership interest? If it's not addressed in the buy-sell agreement, I have two relationships to that company. I was an employee and I am a co-owner. You terminate my employment with the company. That does not by itself terminate my ownership interest. Properly structured buy-sell agreement is thinking about stressing the circumstances in which co-owners will be both employees as well as owners. Will consider this. I mean, because if I've made the determination that I'm going to oust my co-owner as an employee, do I really want to still have them around as co-owner? Often this is not addressed in a buy-sell agreement that's not thought through. It creates a lot of opportunities for conflict. A great deal of mischief can be done from the perspective of a co-owner. And again, ultimately, if that business is succeeding based upon my efforts, that person is no longer contributing to the operation of the business, but they are still entitled to their share of any profits that come off of that. Typically, these things end up in a lawsuit where it's not addressed in a buy-sell agreement. And that goes to maybe, the determination to leave a business is that even in the absence of an employment situation, there's just a dispute in how we're going to handle the operations of the business. What happens when it's a 50-50 business and we just can't get along anymore? If there's no provision to address this question in the agreement itself, if I'm not able to untie that knot based upon an agreement, sometimes where that dispute becomes serious enough and the parties go to court, it's incumbent upon the judge, where that knot can't be untied, to cut it. And in a worst case scenario, what does that lead to? Liquidation of the business or a buyout of someone's interests on a terms that might not be necessarily the fairest or the best for the parties that are involved. So now that we've talked about the triggering events and whether the triggering events result in an obligation to buy or an option to sell. So it's a useful time to transition to that consideration. We talked a little bit about this in the context of the death of a co-owner. And there's a distinction between an obligation or an option. And it depends upon, is there a mandatory duty to buy and sell? Depending upon the circumstances you're facing, that may or may not be a good thing for you. Of course, none of us can know in a circumstance where it's triggered by death, whether I'm going to be the buyer or I'm going to be the seller in that circumstance. And so the different ways that we can kind of handle this situation is that the mandatory buy-sell obligation. So this is the obligation that if that triggering event occurs, there is a duty to buy out on the part of the remaining owners. Alternative would be an option. So that triggering event occurs. I, as the remaining owner, make a determination, is it sensible for me to exercise an option to buy out? I retain control in that circumstance. The converse of that is that I, as the departing owner, have what's referred to as a put option. So it's my determination in that circumstance whether I'm going to make you buy me out or not. Most often, put options, which is probably the least common of these methods, see that occur in the context of a business dispute resolution mechanism, that if we're just not able to get along and I've got to exit the business, that I have the ability to do so. And the consequence of that is that the company or the remaining owners are going to be obligated to purchase my interest. So having talked about the triggering events and whether the triggering events result in an obligation versus an option, let's talk about who does the buying. And so typically in a buy-sell arrangement, you'll see three variations on this. The first is what's referred to as redemption. And essentially what redemption is the company that's purchasing the interest of the departing owners. The alternative is a cross purchase. This is where other owners agree to purchase the interest of the departing owner. And there's a combination of the two, a hybrid, where we essentially have the ability to do either a redemption or a cross purchase. So what does this look like? So from a redemption agreement perspective, how this works is we have a very simple example here. We have a company with two owners, A and B. Each is a 50% owner of the company. So what happens is a triggering event occurs, and the consequences of that is the company has either the option or the obligation to purchase the interests of shareholder A, and in exchange gives the shareholder A compensation, whatever that compensation is going to be under the terms of that buy-sell agreement. After that redemption is completed, we have the company that has one owner, which is shareholder B. Now, shareholder B hasn't directly acquired the interest of shareholder A, but what happens is shareholder B is the last owner standing, and the consequence of that is that whatever ownership interest B has, that is the entire ownership interest of that company. So we think about some of the key considerations that are involved with a redemption agreement. It's the business that is obligated to purchase the departing owner's interest. Often, life insurance is used to fund that buyout. And so when you think about this, is that when it's the company that's doing the buying, and we're going to be talking about this a little further, we have life insurance, that's a funding mechanism. What happens when we don't have life insurance? The company has an obligation or an option to buy. How is the company going to pay for that? Is it going to have the ability to pay for it? This goes to the issue of option versus obligation, because if it's an obligation that the company cannot meet, then it is the company that has breached a contract with the owner who has the right to be bought out. Very often, the focus with respect to a redemption agreement is going to be on the tax considerations that are going to be addressed. They're going to be attended with doing the redemption. And it's beyond the scope of this webinar to focus on all of the tax implications. We could spend an hour plus just talking about those tax effects. Probably the most important consideration is that the disadvantage is that the remaining owners do not receive a step up in basis. And so what's basis? Basis is just simply the amount of your capital investment in the property for tax purposes. It has implications really when I sell that asset, because the difference between what I sell it for and what my basis is going to indicate what the capital gain or loss that I've received. So in a redemption agreement circumstance, I, as the remaining owner, do not receive the value, a step up, an increase in the basis of my capital investment in the asset, because I haven't really funded anything. What I own is now worth more, and I've received directly nothing in exchange for that. In addition, there are some state tax implications that can be involved with this. So by way of example, we'll talk about the circumstance of using life insurance to fund the buyout. And in a circumstance where I, as the co-owner, receive the life insurance proceeds in a cross-sale situation, which we're going to be talking about in a moment, and pay my former owner's estate, my former co-owner's estate for that interest. The company is not involved with that. There's no implication that's involved with it. However, in the circumstance where it's the company that's maintaining that life insurance policy, and the company has an obligation to use that life insurance to buy my interest. If I own more than 50% of that company, for purposes of estate tax, it's considered that the value of that life insurance policy will be included in the value of the business and in the value of my estate for estate tax purposes. And in a circumstance where outside of the buy-sell agreement context, if I was not using a redemption, those insurance proceeds will have no impact on the estate. And this, where it's done through a redemption agreement, that may be included in my estate for purposes of federal estate tax. Depends upon the circumstances of how the business is going to be structured. Am I more than 50% owner? Is that going to be an issue or not? Am I going to have an estate tax issue, depending upon the value of my estate? These are all factors you have to consider based upon the specifics of your business. So move on from a redemption agreement to a cross-purchase agreement, how it works. And so in this instance, same factual scenario we discussed previously. We have a company with two 50% owners. The triggering event occurs. And so what happens is between owners A and B, there's the circumstance where owner A will transfer his or her ownership interest to B. B will give A compensation for whatever that ownership interest is worth based upon our buy-sell agreement. And what happens is we get to the same net result as a redemption. We have B as the 100% owner of the company. The distinction between the two is the key consideration is that really with a cross-purchase agreement, everything that's involved with that buyout occurs outside of the company. And there's really no direct ramifications in the company. The ownership interest is just now held by one person as opposed to two. The difficulty with a cross-purchase agreement can be in the form of administering a plan. Now, my hypothetical where I had two co-owners, very simple. One is going to sell 50% to the other. Let's assume for purposes of our hypothetical that we were using life insurance to fund a buyout obligation in the event of death, and that death was our triggering event. Each of the co-owners had a life insurance policy on the other. Let's expand that hypothetical out a little bit. Let's assume that there are 10 co-owners, and we have a cross-purchase agreement, and death is funded by a life insurance policy. In that instance, the triggering event occurs. and A's estate has an obligation to sell in equal amounts to partners 2 through 10. And in each of those instances, 2 through 10 have an obligation to maintain a life insurance policy on owner 1. They also have the obligation to maintain a life insurance policy on owners 2, 3, 4, 5, 6, 7, 8, and 9 if you're partner 10. Think about how difficult it can become the larger the business the ownership is dispersed to make that work. And so where we get into that situation, typically if I'm going to have multiple co-owners, it leads to the circumstance where we have to focus upon the use of a redemption as being the driving force. From a tax consideration perspective, as I mentioned previously, the life insurance proceeds won't be subject to income tax. In addition, we have the advantage that in this circumstance, because I'm actually paying something for the ownership interest that I am acquiring directly from my departing co-owner, I do receive a step up in basis as a result of the interest that I'm purchasing. Finally, there's the hybrid agreement. And so this is a combination of the first two types. So typically the way that this is structured is the company has the right of first refusal. It makes the decision, is the company going to be implementing a redemption? Now, because the company is just the will, or it's carried out by the will of the remaining owners, those remaining owners make a strategic decision based upon the circumstance in which they find themselves. Is it more advantageous to use a redemption, or is it to do based upon a cross-purchase circumstance? And so they make that decision as part of the structure of the buy-sell. It does make sense to do this as a redemption. And what we're going to do is we're going to have the company effectuate the buyout of the departing owner. Alternatively, if they make a decision as a group, no, it makes sense that we do this on a cross-purchase basis. Then what would happen is that the company does not exercise this option, and then as a consequence for that, then we're going to have the remaining owners exercise their cross-purchase rights to acquire that. Typically, when I do a buy-sell, I use a hybrid arrangement because we don't know what those circumstances are going to be, and because this is going to be driven by tax considerations largely, I want to have that flexibility in the agreement to choose a mechanism that's going to be the best mechanism for the remaining partners. So now we've talked about who does the buying, the question turns to what is the price that they're going to pay for this? And there's really 3 different ways that value is set. First one is circumstance where the co-owners agree to a value and periodically adjust that value. Second is under the buy-sell agreement, they establish a formula that's going to be used to determine the value. And the final is appointing an independent third party whose job it is to establish that value. We'll talk about each of these in turn. First one is going to be a circumstance in which the co-owners establish the value. So typically in a buy-sell agreement where you see this is that when the agreement is first entered into, the co-owners establish a value that they agree to. And then usually that value is intended to be reviewed on a periodic basis, usually it's annually, and the co-owners agree to a new value. And if a triggering event occurs, then because the owners have agreed to that value will be used for purposes of determining how much is paid for the departing owner's co-interest. I used a lot of terms such as intended and used because the disadvantage to this method of valuing the ownership interest is that we as business people have a tendency, once we agree to an arrangement like this, that we take the agreement, we agree to a value at the beginning, we put it in the file drawer and forget about it. And what happens is on an annual basis, we're not meeting to discuss this value. And what happens in that circumstance, if the buy-sell agreement doesn't say anything more, then that value I might have agreed to 10, 20 years ago, does that continue to remain valid? Depending on the terms of the agreement, the answer to that question could be yes, and that certainly would result in an unfair result to someone in the process, usually the person whose interest is being bought out. Second, what happens when we are meeting on an annual basis, we're agreeing upon value, and something happens within that business? There starts to be some dispute between the co-owners. Because this is dependent upon the co-owners agreeing to a value, you have one co-owner who refuses to participate or disagrees as to value because they have suspicion about which way the business is going, and they're trying to be strategic for their own purpose. Does that put a stop to the process? So typically where this method is used to value ownership interest, what we do is we build a backstop in, so that if the parties have not agreed to a value, to redetermination of the value after a period of time, let's say 2 years, that a formula or another procedure, such as appointing a third party to come in and value the company, that will be implemented in that circumstance, so we avoid that situation in which the co-owner valuation procedure fails for lack of carrying through with our agreement. So the advantages to using this as the means to determine value is twofold, really. The first is obviously the most inexpensive method of doing it, because it's the owners themselves who are agreeing to what the value is, and from their perspective, whether they are appreciative of what the true value should be, is a circumstance where we're all bound by our own individual act. The disadvantage, I think, is really twofold as well. First is that, as I've talked about, my experience with respect to these arrangements is that often they're not carried through just because the parties don't follow the procedure under the agreement, even in the best of circumstances where I have used this as a means at the client's request, and I put it in my calendar on an annual basis to follow up with that client. It's only effective as their ability to sit down and work through those issues themselves. And the second really detriment to this is that, while I think I may have an appreciation for the value of my company, and because I'm involved with it, is that an accurate assessment? While I think I may know best about my business, perhaps others feel differently with respect to that issue. So the second step that we can use to determine value of the ownership interest is a circumstance in which we agree up front in our buy-sell agreement that we're going to have a formula, and that formula will be used in the event that we have a triggering event. Some examples of this: various industries have rule of thumb that's used for determining value. Just a real simple example is in the financial planning industry, and that we've been working on the circumstance involved with this in a shareholder dispute context. The value, the rule of thumb in that industry is you take multiples of recurring revenue plus multiples of one-time revenue, depending upon the type of investment product I've been selling. It's categorized as one or another. Add those two numbers together, I subtract the debt against it, and that's how the rule of thumb that's used in that business. Another common example is using multiples of EBITDA. EBITDA is an accounting term, earnings before interest, tax, depreciation, amortization, and CPAs can make a readily determination of what a company its EBITDA is. That might be a statistic that you're already using for your company, just for bank covenant reporting purposes. Parties agree to a multiple of that. They think that's going to be the value that they're going to be bound by. Sometimes you'll see book value being used as the formula that is agreed to. And we'll talk about what book value is a little further down. The advantage, cost effective, in the sense that we've agreed to a formula, and it's just a mechanical application of that formula based upon the present performance of the company in order to determine that. Disadvantage is that those statistics that we're using, they are may not be a true measure of the value of that ownership interest. And that has really a twofold application. First is, that agreement on the value is going to be binding between the co-owners, someone could be a winner or loser in that circumstance. Am I paying more? Am I paying less than I should be? Depending upon the side of the transaction you're standing on, that may or may not be an issue for you, or you could be winning or you could be losing. We take that risk when we agree up front. Second is that while that agreement as to value will be binding between the parties to the buy-sell agreement, it's not going to be binding on third parties who are going to be looking at this issue in terms of what the appropriate value is. So who is that third party that I'm thinking about? It's taxing authorities. So if the owners agree to a value, that determination of value and tax consequences going to be associated with it is not binding on the IRS. IRS is going to be interested upon what is the fair market value of that interest in a circumstance where I'm paying less than fair market value, and especially in a circumstance where it is the buy-sell is being effectuated between family members. Likelihood is that if the IRS takes a look at that transaction, takes the position that the value that was not a representation of fair market value, revisits the subject, determines what the fair market value is. Difference between what I paid, the fair market value could be treated as a gift to the remaining co-owner. This goes to third common means to value the ownership interest, and that's where I appoint a third party that will set that fair market value. And so the buy-sell agreement will establish that procedure. And there's a wide variety of what you'll see in these circumstances. One is the instance the triggering event occurs, departing co-owner, and the remaining co-owners each appoint someone who's going to be evaluation, and maybe those two independent parties will appoint a third, do some type of means amongst three of them to determine value. You got three professionals who are trying to work on one issue. What is the value of that company? Alternative is there's only going to be one evaluator. Then who appoints that? What happens if it's a mutual appointment? It's supposed to be a mutual appointment between the departing owner and the remaining owners, and they can't agree on it. The evaluator will establish the value based upon the terms the owners agree to. And so that independent third party, they look at the agreement and they say, okay, this is what I'm tasked to determine. How am I going to go about making that determination? So the advantages to this using independent third party to determine the value is that because I'm hiring someone who is an expert in this field, hopefully, then in those circumstances that they're going to be giving me the best advice and the closest approximation as to what true value is going to be. Disadvantage is going to be cost considerations. There are people who specialize in performing these services, and there are, for example, accountants whose practice is entirely devoted to this issue. These can be expensive undertakings. It's not unusual to see a valuation reach the cost to perform that valuation going into the five figures, $15,000, $20,000. Is it worth it for my business that I'm going to be incurring that expense? Depends upon the value of the business, depends upon the purpose for which you're going to be using that valuation. If I have a significant estate tax issue that's going to be coming up as a result of the triggering event, and I believe that the IRS is going to be taking a look at what it is, or I'm going to have to substantiate to the IRS the value I come to. Maybe that's a sensible use in that situation. If it's of the company's resources or the resources of the departing owner. If it's a circumstance in which I've just decided that it is time for me to leave the business, for whatever those reasons are, I want to sell, you want to buy, in that situation, is it better that we go ahead and try to come to a value ourselves rather than implementing a procedure that may be more expensive than what we need? So talking about this concept of valuing, often you hear the terminology used, fair market value. And so this is the most common standard of value. And it's one that is used for income, estate, and gift tax purposes. We've talked about some of those considerations in a buy-sell agreement already. In addition, the concept of fair market value is often used in other legal matters, such as marital dissolution, or in circumstances where there's litigation amongst shareholders because a minority is being treated in a unfair manner, and courts will use that fair market value as a substitute, typically outside of the realm of corporation. So using fair market value in oppression litigation related to partnerships, limited liability companies. So what is fair market value? And this is the definition that the Internal Revenue Service has given to what it views as being fair market value. That definition has been adopted by vast majority of courts, other legal realms that have reason to identify and deal with fair market value issues. Read the definition, and if you're like me, you would say, well, that's a lot of gobbledygook. It doesn't really mean anything for my purpose. So what they're trying to do in this circumstance when they identify what is fair market value is that they're trying to make an objective view, removing the dynamics of the specific transaction and making it a number that would be generalized between two presumably independent parties. And that takes out the family dynamic. It takes out the emotional dynamic. It is trying to make an objective standard that's involved with this. So when I ask to a business valuator to make a determination of fair market value, what I'm asking for in that instance is that third party should be considering all of the economic risks that are associated with the ownership interest that's being valued. And very often this takes the form of what referred to as valuation discounts. This is an issue that a lot of times when I'm talking to clients about this, structuring a buy-sell agreement and dealing with it, the issue of valuation discounts is something that creates a lot of confusion. So if you think about it, if I own outright a building, piece of real estate that's worth $1 million, and if I go and I have the ability to sell it on the open market, someone's willing to pay $1 million, that's a fair representation of what fair market value is going to be because it's a willing buyer and a willing seller. Think about, I am a co-owner of a business that owns that piece of real estate. My ownership interest isn't 50% of that building, that piece of real estate, if I'm a 50% owner of the entity. All I am is I'm a 50% owner of that entity, and what that gives me is perhaps a 50% interest in the ownership, the rights to management of the business, 50% interest in the revenue that would be anticipated to come through that business, maybe. What's involved with it is that where I own the building outright, have the ability to sell, in this circumstance where I own 50% of the business, who's going to be my market in that situation? This isn't a publicly traded company. Is there going to be a lot of interest in people going out and buying that 50% interest? What happens when I have less than 50% interest? I'm a 25% interest. Majority rules in my business. So I don't have much control as a 25% minority owner in that business. So in those instances, it is appropriate when you're looking at fair market value to consider those issues and make an adjustment to the value of my ownership interest. Think about the fact that, look, if I'm a non-controlling interest, so I have 25% and my partner has 75%, which one on a dollar for dollar value basis is worth more. Neither of our interests are marketable, but the 75% owner, he has the ability to bring that business to the market to sell its assets. I don't. So in that circumstance, it is appropriate when you're looking at fair market value to make an appropriate discount as to that interest, taking the value of the company as a whole. And then when we look at my specific ownership interest, because the strings there are attached to it, it's not marketable, I don't have control, then my interest on a dollar for dollar basis is worth less than the interest of the person that has the controlling interest. These valuation discounts can be high. I've often seen in circumstances where valuation is obtained that the sum between lack of marketability and lack of control will be 40% discount on the value of my ownership interest. In a pure fair market value valuation determination, in a buy-sell agreement, if I say nothing more than that, and the third party is tasked with going out and obtaining that value, it's appropriate in those circumstances to have a significant discount as to that ownership interest. But in my buy-sell agreement, I do often see this to be the case, that the third party will be specifically instructed not to apply valuation discounts. In that circumstance, because they're following the procedure under the contract, they won't do so. And if I'm the departing owner, that may result in a premium over what's true fair market value. That could be good for me, but if I'm the remaining owners who are in the majority situation, I'm paying that person more than what's fair market value. All depends upon the circumstance you're standing in. And if you're not familiar with this issue, it can often come as an unwelcome surprise to clients when they get to that triggering event and looking at how value is actually determined. Very quickly, we talked about book value as being a means of determining what the company is worth. Understand what book value is. This is an accounting concept. And so all it is I'm taking total assets, I'm subtracting total liabilities. Often book value has no relation whatsoever to the actual value of my ownership interest. Think about a business such as the practice of law, where the assets that we have there on the books, our office furniture, computers, might not be a great deal of value to that. What is the true value is the earning potential of the practitioners and the fees that they generate. Is that correctly captured through a book value determination? And I would suggest the answer to that question is no. It's a very crude means to use determine value, often used by people who aren't really thinking through all the consequences, and it leads to an unfair resolution because it's not a true approximation as to what my business is worth. So in the last couple of minutes that we have available to us, and I do appreciate we're right up against the hour, and I do try to keep these to an hour, is how we're going to fund that buy-sell arrangement. And so really the key considerations is, do we use insurance and payment structuring? How are we going to pay for it if we don't have insurance? And the impact that funding obligation is going to have on the company. So first, focus on insurance. One thing I would leave you guys with when you're thinking about using a buy-sell agreement that's going to be funded through insurance, understand, and sometimes this gets lost in the consideration, a buy-sell agreement is not a mechanism for someone to sell an insurance policy. Any more than entering into a buy-sell agreement is not an opportunity for an attorney to charge you a fee. This document and its implications exist for your benefit. And so insurance has a place, but it should not be the driving factor. And you want to make a decision about the type of insurance that you're going to be using and whether you're going to be using insurance based upon what works for your business. And some of the considerations that are going to be involved with this, first and foremost, is probably the insurability of the owners. Can we buy insurance policies? What's the cost that's going to be associated with that? Circumstance I dealt with a number of years ago was 250% owners in an engineering business. They were probably a 20-year age gap between the two. The older of the two partners was a cancer survivor. So the cost of insuring him was greatly in excess of the cost of insuring the second owner. In that circumstance, was it appropriate for in a cross purchase situation for both of them to have an obligation to pay when the premium that they're going to be paying to insure the other is much higher than, that creates a fairness issue. Second is that very often the company value will outgrow the insurance. I think that the company is worth $1 million today, and there's two 50% owners. We each have a $500,000 insurance policy. What happens when that company is worth 10 years from now $1.5 million? My policy is still $500,000. There's a funding gap between the amount that I'm obligated to pay you and the insurance proceeds that I have to pay you with. In addition, the funding issue can be exacerbated where the departing co-owners are bought out and the value of the remaining owner's interest increases proportionally. And expanding out the circumstances, the example I used, $1 million business, 3 partners, equal shares, one is bought out. The share of the remaining 2 partners is increased proportionally. And then what the circumstances are going to be is that if my insurance policies remain the same, I've created a funding gap in that circumstance. And that leads to, very often, we have to provide for a non-insurance means of funding a buyout. First of all, insurance doesn't cover all of our triggering events. We've talked about death or disability. There are plenty of other ones that we've also addressed today for which there's no insurance policy to cover that risk. And so the expectation in that circumstance of the buyout is going to be funded from the company's cash flow. Can the company meet that obligation? If it doesn't, how do we handle that? One is outside financing. Or do we want the company to have to incur debt to a third party, to a bank, to pay for the exit of a departing shareholder? Second is that the departing owner holds a note, very, very common in these circumstances, creates a risk to the departing owner, the credit risk that there's going to be performance of the company or the remaining shareholders to pay that note. Second is there's not true separation between the departing owner and the company and the remaining owners. You've just converted someone who was a co-owner to a creditor. Third mechanism is what's referred to as a sinking fund, and this is where I'm essentially putting money aside and building up a treasure chest that I'm going to use to fund that buyout obligation. Great in concept. Reality is that there's plenty of demands for our funds as a company to operate, to have distributions in the present. Am I going to have the discipline to fund that? And so I appreciate that we've gone a little bit over our hour. I have a couple of questions that have been received. I think for the interest of everyone who's participating today, and I know that you guys have made demands on your time in these instances. I will address the questions I've received offline. I'll do so today. And in addition, I want to thank you for participating. I've have my contact information here. If anything happens offline that I can be of assistance with, thoughts that occur to you, I'd be more than welcome to address those instances. And again, I want to thank you for participating and have a great day. Thank you very much.